If you brought a medical malpractice case or an accident case, if you stop receiving medical care and treatment, is that going to affect the value of your case? Would you like to know the answer? Come join me for a walk around the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, yes, it will. Now, you might be thinking, I know how badly injured I was. I know what type of medical care and treatment I had, and I know I'm going to be totally affected and totally disabled for the rest of my life because of my injuries. And you believe that these injuries are all a result of either an accident or a doctor who was careless. So now, you were told by your treating doctor, listen, there's no more treatment that we can provide to you that's going to change or alter your outcome. You don't go to a second doctor. You don't go to anybody else just to get a second opinion to see if you still need ongoing treatment. Your doctor, who you rely on, who you trust, who's been taking care of you since you suffered these injuries, has told you no matter what anybody does, you are now going to have to live with these permanent, lifelong injuries. And you're thinking to yourself, okay, there's nothing more I can do. I'm going to have to somehow live with my injuries, and I'm never going to get better. And your doctor has basically told you you will never get better. Let's say it's just the opposite. Let's say you do have a need for ongoing care and treatment, and that you do need to continue seeing your doctor. Maybe it's a surgeon, and maybe you will need ongoing surgeries over the course of time to correct the problems that you suffered as a result of a doctor's carelessness. If you choose not to go, now what are you doing? You are hampering and limiting your ability to try and document your ongoing injuries, your ongoing complaints, your ongoing limitations and disabilities. Now, why is that a big deal? It's a big deal because when you bring a lawsuit seeking money as a form of compensation for all the harms and damages and losses that you suffered, if you do not document with a medical doctor those complaints and problems you're having on a regular basis, how is the defense ever going to know that what you are claiming is true? The logical thinking is, if a person has a problem, and now they go to a doctor seeking to alleviate that problem, you're going there with the true intention of trying to get better. You're trying to do everything possible to improve your condition, your medical condition, and your status. If you don't go back to a doctor, now there's no way for you to be able to document your ongoing complaints, to document exactly what the doctor did or did not do, to document what the plan of action is. And if there's no way to do that, then what's going to happen is during a pretrial deposition, which is a question and answer session during the course of your lawsuit, where the defense attorneys have an opportunity to question you, to learn from you in your own words exactly what happened and what injuries you have and limitations as a direct result of this carelessness. And now what they're going to do is have you describe in your own words exactly those things you can and cannot do today, and how they are different from what you used to be able to do. Do you think they're going to rely just on your word? No. They want to be able to see medical evidence that your injuries really are as significant as you claim them to be. Because you, as the injured patient, as the injured plaintiff, you have a vested interest in your case. So their thinking is, the defense thinking is, you're going to say whatever you think is right in order to maximize the value of your injuries. But now they have to go back and do their due diligence to see whether or not what you are claiming is really true. And how do they do that? They do that by obtaining your medical records. They do that by scouring through every single page of every medical record you have, to look for complaints, to look to see what treatment you received, to look to see what rehabilitation you received, to look to see what medications you were on. All of these things are critically important. And if you no longer continue treating with your doctors, guess what? Then there is no possible way for them to know exactly what your problems and ongoing complaints are. They will assume that if you stop treating with your doctors, that there's no more need for you to obtain ongoing care. And they will believe that your injuries are now limited, that you will not have any ongoing medical issue, and that now whatever you do have, that's the finite period of time in which your injuries have existed. And if there's no potential for improvement afterwards, guess what? They will conclude that you, the injured patient, now have limited injuries. So does it make a difference? The answer is absolutely. It will make a significant difference. Now let's go back to the original scenario that I talked about in this video. What happens if your treating doctor tells you that there's nothing else to do for your injuries? No amount of surgery, no amount of medication, no amount of further rehab is ever going to change the injury that you have. That is a different scenario. In that instance, you're going to explain that your doctor has told you that there is no additional improvement you can ever expect regardless of what medical intervention occurs. So why do I share this quick information with you? I share it with you just to open your eyes to help you understand how these types of cases work in the state of New York. Cases involving medical malpractice, accident cases, and even wrongful death cases. You know, I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.